Good evening and welcome. Today, Me-Arcone Season 9, Episode 3, proudly powered by the Institute of Alternate Dispute Resolution, an organization dedicated to transform conflicts into solutions through dialogue, empathy, and innovative problem solving. I am your host, Naveen Oja, and today we are exploring the power of communication to heal divide in our episode Safe Spaces, Stronger Ties, the Art of Constructive Dialogues. Today's guest is a dedicated conflict resolution professional who has spent the last 18 years in transforming disputes into opportunities for understanding. Mr. Advocate Amit Ahuja, sir, is a highly skilled mediator and currently a practicing advocate at Delhi High Court. Over the course of his career, he has handled a wide spectrum of disputes from family and matrimonial cases to workplace disagreements, commercial matters, and community conflicts. His mediation journey spans hundreds of successful resolutions where he has worked with individual businesses and institutions to address not just the legal aspects of disputes but also the underlying the human emotions and broken communication and the fuel them. Known for his calm demeanor, empathic listening, and ability to create safe spaces for dialogue, Mr. Amit Sir has earned the trust of both clients and fellow professionals in the field. With his unique blend of legal expertise and people skills, he stands as a bridge between conflicts and cooperation. Mr. Amit sir, we are truly honored to have you with us today. So, if sir, you may allow, we would like to begin with the podcast.
Yeah, please, we can start.
Sir, before we begin, the very basic question comes in my mind. Why, sir, why mediation, sir? Why mediation is important? Why people prefer mediation over litigation? So, the first question,
Basically, if you see that mediation in India, basically it dates back to the Vedic age. So in ancient days, disputes were resolved in a panchayat at a community level by Panch Parmeshwar, who acted as a neutral third party.
okay.
With the onset of British colonial rule, mediation began to recognize as a formal and legalized alternative dispute resolution mechanism. Because as our Code of Civil Procedure was passed in the year 1908, so it was being designed at the time of British era, and thereafter, time to time, we have when we got independence and when we had that constitution came into the force, and with the advent of all those civil litigations, there was a need. Means after a span of I think more than 50 years, it started. Means there was a need for getting a alternative dispute resolution mechanism, and thanks to that Salem Bar Association judgment, which came in the year 2005, and because of that, we had that kind of amendments in our CPC. And with that particular thing, courts starting to recognize this is the best mode of resolution by giving the opportunities to the parties to go to the mediations, settle their disputes, save time, energy, resources, as well as the most important thing, to go back from the court in a win-win situation. Because in a litigation where one party loses and one party wins, there's always an option open which is being given by the legislature by way of a appeal. And then there is a second appeal. And at last, we have a resort to Supreme Court, whether it's a statutory appeal or whether we are going under Article 136. So with that long drawn litigation and with that background, that basically that it's a time consuming as well as it's a very expensive process. With the set of that mediation, both parties can bind themselves to a process wherein they are binding themselves to an agreement, and that agreement is being drawn voluntarily with the help of the third party, who is a neutral person called as a mediator, whose role is basically nothing more than a facilitator. He can't be a referee or a judge. He is not required to take any kind of a decisions. So in that way, if basically we see that mediation has played a great role, and that's why with the coming new acts, Commercial Court Act made make a pre-mandate to have a pre-institution mediation. And with that passing of the Mediation Act 2023, it has really made an impact on the society that yes, we need mediation as a one of the source of getting the matter being settled at the mediation centers.
Okay. So basically, it's not a new process. It's came from a long time period.
Yeah.
So, sir, the next I want to ask you, like, when both sides believe they have already tried talking and failed, how do you reframe dialogue so it feels new and worth engaging in?
Naveen, actually, to revitalize the dialogue after past failed attempts, a mediator can reframe the conversation by focusing on the interests rather than position, emphasizing active listening and empathy, not sympathy,
Okay.
and creating a safe space for open communication, shifting the focus to shared goals and future outcomes can also make the process feel more constructive and worthwhile. Like, for example, like basically, if we go further, like shifting from position to interest, the role of the mediator is to listen the conversation of the parties very actively instead of focusing on what each side wants. Delve into why they want it. Active listening involves truly understanding the underlying needs, concerns, and motivations of each party.
Okay.
Then you need to reframe the things, like help parties see their positions, help the sorry, yeah, help party to reframe their position as a potential solutions to underlying needs rather than rigid demands. So basically, once you feel that basically that other party is being tagged, because what happens in a litigation when you're into a court, there have been so many times the judgments are being taken, dates are being given. So as a mediator, as well as the lawyer for the parties, because I need to make my party motivated to go for a mediation center. He asked me a question. So what's going to happen? He's not going to hear the things properly. So I make him understand basically the thing that you are in a litigation already. So you're already in a situation where you have not come happily. Either it is a forced litigation or you have been wrongly implicated in that litigation. So in that particular situations, the most important thing, either for the mediator or I say that basically the lawyers also play a very important role if they motivate the parties to go for a mediation, if they make them understand that the amount which they are spending on litigation, if they save that amount and use it for some constructive purposes, it can be a very fruitful exercise. Like for example, a live example would like to give it to you. One of my party I was representing the lady in a matrimonial dispute,
Okay.
and she was like fighting like anything. And from the other side, the obviously the husband was there. The father has also filed certain that guardianship petitions and other things, and they have been fighting like anything. Many of the matters were going in the Supreme Court, High Court. Some appeals were there, and we were at the district court. DV domestic violence petition, divorce petition was pending. So I was just analyzing that at the end of the day, the at least 11 to 10 to 11 matters were pending before different forums.
Okay.
So I asked a very important question to both husband and wife who were sitting over the. Luckily, the other side lawyer was not there. The husband lawyer was not there. So I asked a very pertinent question to,
Sorry to interrupt,
and
but
you've
your voice
almost
is
spent
cutting.
more than 35 lakh rupees on this litigation, roughly, which I would have saved that. Sorry,
Sorry, your voice and video is.
am I audible?
So your audio, yes, it's now it's good. Yes, now you're good.
Naveen, am I?
Sorry for the glitch, sir. There, there's a internet connection problem in here in the basement. So
Naveen, am I audible right
yes,
now?
yes, yes, sir. Now you're audible, sir.
Should I start from the place where we left, or
No, sir,
do I need
where
to
we
restart
left,
the fix
we can
again?
start from the way we left.
Okay, so I was just basically like telling that what a kind of a thing which I made the parties understand. So basically, we will say it's basically a brainstorming technique. So I mentioned it to both the mother and the father that you have already spent almost a span amount of more than 25-30 lakh rupees on the litigation. So it would, and what I see is that basically that it's more than a span of 9 years also it's in the litigation. And another 10 years down the line, you may both maybe they're here in the litigation only and spending another 25 lakhs. So why don't you save this money on a fixed deposit and settle the dispute for the welfare of the child via mediation process and go sit with the open things. And I think the amount which you have spent on the lawyers, this can be saved on the child's education and he will get a better education at the end of the day. And that brainstorming technique clicked their minds, and it was a totally drastic change. They came to the table. There were 3 to 4 sessions were there. We were very lucky to have a good mediator. He also made them understand. And with that, space, ground realities, reframing of things, they came to a settlement and they happily went thereafter. Although both were separated, they took divorce, but that child custody and that particular thing they did it mutually, and the amount which were they were going to spend it on that litigation, they decided that they are both going to contribute.
Okay.
First, the dispute was there that why the husband is going to deposit that amount. Then the lady also realized, she said that you are right. I would have spent easily that much amount on the litigation. And then she also deposited that amount, and father deposited a larger extent amount. And the matter was settled. And at the end of the day, we settled 12 disputes with
Okay.
that one mediation.
Okay. So basically, the mediation is much more cheaper than litigation also.
It was much more cheaper. Rather, it basically they both went happily from that
Okay.
particular situation. The reason that they both were contentful that what exactly they wanted. In one of the situation, either one of the person has won and another one has lost, and again there is a sort of fighting the appeal and defending it. So all those kind of a things they saved it, and at the end of the day they went happily. Happily means in a win-win situation.
Okay.
Nobody won, nobody lost. Both won from that mediation center and went with a concrete solution.
Okay. Okay. So the basically, sir, there's one more question in my mind that when the mediation, when the both parties in the mediation not agree in the negotiation at what the like demands for the negotiation, so how a mediator can
Hmm.
resolve this? Because mediator cannot give their his opinion on the parties. So
Yes, in that particular situation, mediator role is a very challenging one, and he need to understand that he need to make parties understand that you need to break down certain cues
okay.
that from you always you need to convert it I feel, right? Accusatory statement that your party did this, you were supposed to do this, create defensiveness.
Okay.
Shifting to I feel statements allows individual to express their emotions and experiences without directly blaming the other party,
Okay.
fostering a more empathetic environment.
Okay.
Like another example, that's not fair. Means if somebody is giving that an option that no, I want this much amount of money. Like if I take that situation, the previous which I have discussed, that mother is saying or wife is saying that that's not fair that he is not paying that much of the amount. I went to that particular place. So in that situation, the role of mediator is he should say to the party that help me understand that what was the problem. So by mentioning this thing, instead of dismissing the other party's perspective, this shift demonstrates a willingness to understand their point of view, even it differs from their own.
Okay.
Instead of interrupting, like if he's mentioning certain things, he should keep on listening.
Okay.
And with that listening, he should ask certain tentative questions also. Like, silence can indicate a lack of engagement or disagreement. Like if you're saying something, I'm just listening to you like this. So definitely it may be a kind of a lack of engagement. Tentative question phrased in a non-confrontational way. You're not confronting it. You're trying to understand that, okay, so this happened because of this particular situation. Then we need to fix this to how can we work together to find a solution.
Okay.
So you are asking both the parties that how can we fix this, means how we can make this situation possible working in a proper manner. So for that particular situation, we are involving both the parties.
Okay.
And for that, there are certain process of mediation which you must have studied in your law college,
Yes, sir.
that you need to give ample time to the parties by having
Yes.
caucus, by having the techniques of Batna, Whatna. So all these techniques, application of techniques and listening them in a proper way can reach to a further practical solution.
Okay. So, sir, the next one is like, what's the most subtle, often overlooked shift in communication you have seen that signal trust was starting to rebuild? What your thought about this?
Okay. Basically, with respect to this thing, that you need to see the body language of the parties.
Okay.
Because there are sometimes when the parties enter into the mediation center with the lawyer, they come with a very aggressive mode.
Okay.
With that aggressiveness, they start saying this thing that we never said yes for the mediation. They were the one who took active initiation in getting the mediation. You ask them what is your offer.
Okay.
So in this kind of a situation, manipulative tactics are required to be done. So these might include shifting blame,
Okay.
using emotional appeals to distract from the issue,
Okay.
making exaggerated or employing. So these kind of things which the other parties are going to do.
Okay.
So mediator is required to make a difference between genuine concern and the manipulating strategy. So for that, he is required to make certain ground rules and structure so that one party should not be aggressive and dominating in that particular situation, or behave in such a manner that other party think that basically they are so much of aggressive, or they are basically making the other person in a lighter manner. So then the important rule is create a safe and respective environment.
Okay.
Clear ground rules from prohibiting personal attacks,
Okay.
interruptions, attempt to dominate the conversation, active listening and empathy, which I previously mentioned,
Yes.
focused on the interests, help party to identify the underlying needs. Like, for example, I give you a practical example because I do a lot of property matters also.
Okay.
So there was a situation wherein a partition suit was filed by the other side. I was representing one of the defendants. The defendant who was in a dominant position in a partition suit, there were three floors down, first and second. And second, there was a roof. So my client was in the position of second floor with roof.
Okay.
So he said that why I should, you give me one reason that why I should get myself uprooted from this property, why I should come for a mediation. So the role of the mediator there was a very challenging. So
Okay.
he asked that particular person that this is a partition which has been asked for. You are totally five brothers. How they were residing, one brother on the front portion of the ground floor, another one on the back side,
Okay.
then another one on the first floor front side, last one, fourth one on the back side of the first floor, and the fifth one on the second floor. He was having the half of the second floor with that open area
Okay.
and having the roof where the water tanks were being kept.
Okay.
So ideally, the property was more than 60 years old. So
Okay.
mediator asked one thing, that what is going to happen after a span of 15 years. You are here in 2025. I asked you the situation that what is going to happen after 15 years down the line in 2040.
Okay.
What is going to happen? If you win, if you win means if I am being successful
Okay.
in
Okay.
getting their partition suit dismissed,
Okay.
what is going to happen? The property is right now 65-year-old. It
Okay.
will become 80-year-old.
80 years old.
And if you find a solution right now, you can redevelop this property, have 4
Yeah.
floors.
Okay.
You can contribute some amount and give to the fifth one if he
Okay.
is ready to go out and come out with a workable solution. Have one basement also. Give
Okay.
that basement to that person so that he can work there and give some amount so that he can buy that particular property. So you're going to buy that piece. And the most important thing is the better living. You are
Okay.
right now in a property where basically the second floor people that my party was demanding that why I should be. I am living in a comfortable way.
Okay.
So the another lucrative offer was that you will be getting the top floor with the roof height with the new construction.
Oh,
So right now you're in the half portion. You will get the complete portion. So you gave that kind of an option. That was a collaborative problem solving technique.
okay.
So with these things worked into the manner, and we are almost in the process. This is the mediation, which is ongoing process, which I have given you the live example.
Okay.
So we are almost in the process of getting the thing settled. We are
Okay.
having a finger crossed. I hope so we will be able to do that.
Okay. So I think you're trying to say like we have to give them a better solution or a better view of the future so that they can understand what are we want to like convey them. Is that right, sir?
Sorry, can you repeat? So sorry, can you
So,
repeat your
so
question?
basically, we have to give a view of the future. So, how the work is going, and after like some
Yes.
years, what problems or what things are going to arise. So, it's better to like resolve this right time. Okay.
Yes, because one party is coming in a different a kind of a body language.
Okay.
So we need to make them calm down, listen to them very carefully, find out the options which are available in that given set of circumstances, create that atmosphere so that parties can come up with the open options, give the parties to option to come out with the different ideas. There might one party might be coming with two ideas which is not acceptable to
Others.
one party, maybe three of them are ready to agree to this thing.
Okay.
So in that particular situation, like in this same situation, there was an option that parties were wanting at one stage that they don't want that any of the parties should be staying in that property.
Okay.
We have to sell this property and let that amount be deposited that shared in 5 equal parts.
Okay.
So in that particular situation, a kind of a solution which came from the mediator when he took that individual corpus, that why you need to inform the other party that you want to buy this, you want to retain it. You talk to a builder, you come with the builder, you have some internal arrangement with the builder. Let this property be sold to the builder. The funds which a builder is going to give it to you, you purchase that particular floor, that particular fund, so that that ego gets satisfied and everybody is free to have their own shares wherever they want.
Okay. So basically, it's when we have to like show them what the consequences if they don't follow our like suggestions or the like we want to like convey them. Okay. So, sir, how do you navigate situations where one party use dialogue strategically to stall or manipulate rather than genuinely resolve the conflict?
Yes, this is a very pertinent question you have asked because most of the times parties tend to take these kind of a techniques by requesting the court to send the matter to mediation
Okay.
by wasting a good amount of time there and then coming back to the court and again started fighting and all. So in that particular kind of situation, because we need to understand one thing, that one of the most cardinal rule of mediation is that both the parties, or if there are more than two parties, all the parties are willing to join mediation. So if
Okay.
any of the parties who is not ready to give consent, in that particular situation, court is not going to refer you to the mediation center.
Okay.
So first of all, the prime importance, the precondition is to have consent of. Now, coming to your specific question, wherein the consent is being given specifically just to stall or delay the process.
Okay.
In that particular situation, the role of mediator is very, very important again. He
Okay.
need to gauge, because once you are there on the mediation center, he is going to have the conversation with the parties. He will he will understand that what was the dispute. While understanding the dispute, he always have to keep in mind that he is not a judge there. He's not there as a lawyer. He is a neutral person who is required to make a disclosure that he is not being connected to anyone. He is, if in any way he is being known to anyone, he is required to that disclosure. It is a prerogative of the party whether they want to continue with that mediator or they can get the mediator changed. Or even otherwise, parties are having a proper choice. If they think that that mediator is not acting in a proper manner, they can make a request to the mediation center for the change of the mediator. That
Okay.
mediator can be changed also in that particular situation. So the person who is acting as a mediator, he is required to gauge the things very carefully, that while listening to the parties and understanding the proper problem, there should not be any kind of a malafide that it seems coming from the other side, that other side is taking adjournments or taking gaining time by taking times and again. Because at the first or two sessions, it will be very difficult for a mediator to understand that whether the party is here to just to gain time or just to, or is genuinely interested in mediation. So
Okay.
in that particular situation, he need to understand that what is the root cause of the problem. And then in that particular situation, when he starts inviting the parties to come out with some possible solutions, from there we get that kind of a sense that yes, he is genuinely interested or he is just wasting the time.
Okay.
So if he is not at all interested in that particular situation, the time bound, because if he's asking for time, we can't straight away say that no, we are not going to give time.
Okay.
But yes, we are not going to give that much of the time. Like we are giving 4 weeks time, 5 weeks time, or we need to have a time bound things. We're
Okay.
going to give him a reasonable time so that mediation should be fruitful. So that some kind of a reasonable offer is coming from the side, and the gap between the one party and the other party is not that much. So if the things are foreseeable before the mediator, that the gap is a very less one, and it can be done by way of giving some more dates. He should give that much dates to the parties. But if the gap is too much and still the party is requesting for the time, there the role of the mediator comes. He should take a call and refer the matter back to the mediation, refer the back to the court by mentioning that it is not a fit case for mediation because the gap is too much. So this kind of a thing can be done. Again, the same things by way of encourage active listening, transparency by giving the details, clear communication channels,
Okay.
conflict resolution skills, dialogue facilitation, all these kind of parameters the mediators should employ all these techniques to find out that whether the party is genuinely interested or it is just a time gaining technique.
Okay. So basically, it's on a mediator to understand what the party want. Basically, they
Yes.
really want to like resolve the problem, or they just want to like waste the time of the court and the mediation center.
By
Okay.
asking them to come out with some options,
Okay.
so that, because if you are ready to solve it, you tend to have certain options to get it solved.
Okay.
And if the options which are coming and the options which the other party is giving it to you, the gap is too much, then definitely there is no possible reason that that matter can be settled. So in that particular situation, the role of the mediator is that how far he can stretch that party to come little bit. Like, for example, mostly in the matrimonial litigation, if a lady is asking for a one-time settlement amount of rupees 50 lakh rupees,
Okay.
and the boy side is saying that we can't give more than 7 lakh rupees.
Okay.
So the gap is 43 lakh rupees. How are you going to bridge that gap? So you need to make them understand the boy that why he is giving that kind of an offer. So
Okay.
boy will give you the circumstances and explanation that, sir, this is my income. This is what I earn. If I give 43 lakh, I need to take a loan. I will be giving the entire my lifetime that loan payments to the banks, and that's not going to give me a fruitful purpose. So for what reason I'm here at the mediation center? Then you need to ask to that lady that for what purpose he's asking for 50 lakhs. That
Okay.
what is the rationale? So basically, if she sees that my jewelry is like the jewelry worth rupees 30 lakhs is already in their custody, if they return back that 30 lakhs, that my jewelry to me, I'm ready to go forego 30 lakhs. So then automatically the gap comes to 20 lakhs.
Okay.
So then the role of mediator comes that he will ask that jewelry, he's saying, is going to say that no, we're not having the jewelry. So he will ask that basically that if you have the jewelry, because this is a confidential process. So don't think that if you are going to admit it, the situation that you are having the jewelry. So if tomorrow this mediation gets unsettled, so the admissions which you have made here in mediation cannot be used against you in the 406-498 proceeding, which is a criminal law proceeding, IPC proceeding pending before the court. So it
Okay.
won't be used. So you need to come out with a fair offer. So if still he thinks that he is adamant about that particular amount and she is adamant about that 50 lakhs, so that is not a fit case for mediation. He is bound to send it back. And if he thinks that yes, the party is still taking date and they are not coming forward with further extension of that amount, that offer is not getting increased, in that particular situation, mediator is bound to send back matter to the
Okay.
court,
So
questioning
basically,
it not.
okay. So basically, both the party have to come with like a good offer so that they can accept each other.
Yes.
Okay.
Yes.
So, sir, with this, we have reached towards the end of the podcast. I would like to extend my heartful thanks to the sir. Thank you, sir, for sharing your experience and insight. Your work reminds us that a peace is not just the absence of conflict, but the presence of understanding. To our listeners, remember dialogue is not just a talking, it's a listening, respecting, and finding common ground. On behalf of Institute of Alternate Dispute Resolution, I thank you, Advocate Amit Sanduja, sir, for joining us today. It's been an absolute pleasure. Thank you, sir.
Naveen, at the end, just a one metaphor which I read somewhere. It was very nice. So I would like to share
Sure, sir.
that. I know that time is running out of here, right? But one phrase which I read somewhere, it was like mediation is like tending a campfire.
Okay.
You need the right conditions. That
Okay.
is oxygen, fuel, space. And you have to protect it from sudden gusts that can blow it out. You can't force it to burn faster. You just tend it patiently until the warmth spreads. So
Okay.
with this thing, I would like to say thanks to the Asian Law College for giving me an opportunity to interact on this, my favorite topic, which is mediation, because I had the opportunity to appear for many parties as an advocate in the mediation center and being the mediator also. So with this kind of a thing that colleges are giving so much of due importance to mediation with the era where the Mediation Act has been passed,
Yes, sir.
I feel I think I see a bright future coming towards the mediation, and hopefully so that with this kind of a thing, the litigations will lessen down, the burdens of the court will lessen down, and most of the people will strive towards the mediation and will get the matter settled successfully. Thank you so much. Thank you so much for
So much for your time, sir. Okay, now I'm going to like stop the recording.